So to go back to illustrating the diversity, I just want to take two examples to show you the challenges that any setting of standards can have in India, and we must recognize them and work with them. The first example I'd like to give you is from the northeastern state of Nagaland. The Chief Justice of Guwahati High Court has asked us to come with an awareness program for the Northeast, especially the state of Nagaland. We went there and we thought, the Nagas are a wonderful tribal community. There are 17 tribes of the Nagas in Nagaland. The rest live elsewhere. All 17 have different languages. They don't speak each other's languages. They communicate with each other, these 17 tribes, through a language called Nagamese. And this Nagamese language doesn't have a written script. And in that environment, when we went, we were really so pleasantly surprised to find that without knowing the nomenclatures of mediation, the hierarchy of the village council, then the village panchayat, and then the village appellate customary court, which coexist with the normal judicial courts. I mean, mediation was being practiced without their even knowing it. They were making the opening statement. The wise old man known as the Gaon Buddha, he gathered information. He had his joint session. He had his separate sessions, his private sessions. He unearthed underlying interests of both the parties. He encouraged them to throw up options. He helped them to select options. He spoke of confidentiality, voluntariness, all the tenets of mediation. We were really surprised to find. So how do you set standards for a region that has been practicing mediation for centuries? Yes, today the challenge is how do we help them set standards to write, say, a settlement, in the writing of a settlement agreement. So that's one example. And I want to give a quick second example of a district in the state of Punjab. Now, we went there to train lawyers in mediation, and we were talking about neutrality, how it's important to set standards of neutrality, and therefore, for that, to avoid appearing for parties where you've been a mediator as a lawyer, say for a year or a year and a half or two. Now, when we were talking to them about this, they were really surprised because they said, we come from it's a very poor district. There are very few educated people. There are generally farmers who till land, small bits of land. There are shopkeepers. There are hardly any graduates. We know how difficult it was for us to actually get law degrees by going long distances for years. Now we are the elders and leaders of this community. We are looked upon to write any legal documents that the people around, the people of the district would like, informally, formally. We are their mentors. When they have a family problem, they come to us. When there's a family celebration, they come to us. When they need money, they come to us. When they want help in the court, well, half the time we are doing it pro bono, but we are a handful of lawyers who are looked upon as leaders by the entire community. And this community just cannot see any ethical contradiction in our knowing all of them and them knowing us. In fact, they would not like to come to a neutral person. For them, we would be the right, mediators because we know the community. So, so how do you set standards for specific requirements? So the point that I'm trying to make is that it is very important to decentralize. We'll talk about it, I'm sure, in the course of our discussion. To decentralize the applicability of standards when we set them in recognition of the local conditions. That is critical for India.